Yeah, move your hands up, move your
No, no,
hands.
no.
That's
When you're
it.
talking, it's normal to have your head animated,
All right,
and then
all right.
after you're done, stop.
And think about what you're going to say.
Right.
It's just like you're in the courtroom
We
again,
can do it all.
right? Okay, yeah.
In all honesty, that would even, if your hands stayed more like that, maybe a little bit closer together than anything other than this,
Okay.
okay?
But you sounded great.
Yeah.
I
Yeah.
thought what you
Sound
said
good,
was really
Cindy?
good.
Yeah.
Sounds good, okay. No, Russell? Okay, very good, Kate. I'm just gonna do this because I have to sync this up in the camera, you know. Okay, you know, you don't think that makes it's important. Okay. Okay, so then what happened? Why did they go to trial? Why did they think you would not go to trial?
Well, I think that's part of the reason. They didn't know if Robin would have the courage to turn down what wasn't a fair settlement. What the offer wasn't unfair, but it just wasn't sufficient. And I think also they wanted to make sure that we as attorneys could try the case and do a good job. So in some ways I think it was a test. So that's part of the reason. But the other reason is, like happens in a lot of these cases, they challenged us. They said that the accident was Robin's fault. And they brought in an expert to say that it was Robin's fault. They challenged the extent to which Robin would be able to work in the future. We think the evidence showed that she wouldn't be able to work because of her leg fracture and because she's a blue-collar worker and always has been. They hired an expert to say she ought to have a full-time job, she ought to be able to go back to college, et cetera, et cetera. They hired an expert life care planner to challenge some of the medical procedures that she'd need in the future. So part of it was a challenge to Robin and our firm, but part of it was also that they challenged the evidence.
Okay, I'm going to ask you, that was wonderful. I'm going to ask you to do one thing just now because I'll cut it and put it in the front. Say, we think they went to court because. If you can just say that, or that part, because I'm not going to be in this movie at all. You're the star. My voice is cut out. So when I ask a question, if you just repeat the first part so that they know. Okay, so and you say, when I say, why do you think it went to court? You say, I think it went to court because they were challenging us.
Right. I think they went to court because they wanted to see if Robin had the courage to go to trial. They wanted to see if I and Doug, as attorneys, had the courage to put on the case and try it. And they also wanted to go to court, or made us go to court, because they were challenging the evidence. They were challenging whether Robin was at fault. They were challenging her ability to work and the extent to which she'd need future procedures as far as medical and a life care plan.
How did you counter their challenge in the courtroom?
Well, number one, Robin is a great person who made a great witness, very honest, very believable, very hardworking. We had some of her friends and family members come testify about how she was before, how she was after. We had our own trucking safety expert come testify about the rules for proper securement of a box truck. We thought that evidence was very powerful. Actually, our first witness in the case was the truck driver. He claimed that he didn't remember what had happened. So we put him on the stand for about 20 minutes going through what he did and did not remember as far as the accident goes. And then on the medical side, the damages side, as we call it in a civil lawsuit, we had our own life care planner who worked very closely with Robin's doctors, her treating physician, and we had our own vocational expert to talk about the challenges that she would face in the future when it comes to getting a job. And then finally we had an economist who was able to reduce those numbers to present value. So through our own experts and through our clients is how we met that challenge.
Now, did you well, that's a stupid question. Did you expect a victory? I mean, you always win, right?
No, ask me that. That's fine.
Yeah, okay. Then tell us, did you expect a victory?
Absolutely. Absolutely. We were very confident in our client. We were very confident in our ability to try the case well. We were very confident that the jurors and the members of this community would see the evidence and view the evidence in a fair light, and I thought they reached a fair decision. I do. I mean, you never know what's going to happen in a case like this. Trials are always risky, but we were very confident in our evaluation, yes.
And you think that the competition...
Do one thing. When he asks the question, wait about a second and a half and then start answering.
Okay.
You're coming in right after he starts, and you may not have any cut.
Right.
Okay.
Because you said it, he said absolutely, and you just barely finished your word.
Okay.
So if that's an important thing, I'd have him do it again.
Okay.
Okay.
Say, and I want you to say, we expected to win this case. That's
Sure.
why we went to court.
Sure.
Give about 2 seconds before you start answering.
All right. We expected to win this case. We weren't surprised that we won this case. We were confident in our client. We were confident that the jury would understand her and believe her. We were confident in our own ability to try the case, and we were confident in our evaluation. I'll tell you how confident we were. They made a $900,000 offer the Monday morning before trial. Our bottom line was $1 million. We said not a penny less. We meant it. So we turned down the $900,000 and tried the case, and we ended up doing better.
Wonderful. Now, can you say what you got? Is it? Or
Yeah.
Yeah. Go ahead. What was the decision?
The verdict was $1.565 million, 75% of the fault to the truck driver and the trucking company. Unfortunately, 25% of the fault to Robin, which we disagreed with. We always respect a jury's decision. I understand how they arrived at that decision, but it was something we were a little disappointed in. So the way it works is the 1.565 is reduced by 25%, so the net figure that will go to Robin and her family. I'm in here filming, Pat, so could you hold my calls?
Okay, well, I just want to let you know that Ms. Wilkins.
Okay, thank you.
And let's do that again.
Let's do it really great. Here we go.
What happened?
All right, go ahead.
I'll start with the verdict.
Yeah. Okay.
Yeah, the verdict was returned in the amount of $1.565 million. 75% of the fault went to the truck driver and the trucking company. 25% of the fault went to Robin, which honestly we were disappointed in, but understand that the jury from the defense, they heard all week about Robin did this, Robin did that, she shouldn't have done this, she shouldn't have done that. They were doing their job. We don't begrudge them or blame them for that. But under the law, the figure has to be reduced by Robin's percentage of fault. So after you reduce the 1.565 by 25%, it gives you approximately $1,175,000, something in that range.
Something I'm seeing. You're thumping your hands.
It's because I'm getting pissed off.
That's okay. That's okay. I like it. Okay. Well, I find this was good. No, that's good.
All right, I'll stop doing
I like that. That's how I see the face.
It's like-
see the face.
I think you're gonna have to say that last phrase again, because you jumped on it.
Yeah.
I'm sorry.
Okay,
Go ahead.
that's okay.
Go ahead.
Under the law, when you have a verdict where fault is assessed to your client, the verdict amount has to be reduced by that percentage of fault. So in this case, 1.565 million had to be reduced by 25%. So the net judgment to Robin is approximately 1.175 million.
Very good.
Hands are, you're really relaxing.
Okay.
Okay.
It's
That's
really good.
And we can turn off the camera, stop, and we're done.
Oh, are
I
we?
think that was perfect.